If it pleases the court, Joseph Zemanowitz of Stone Zemanowitz, and we represent the defendant's appellants. The court should have granted summary judgment because there were no damages here. In fact, I heard, Justice Kaplan, your comment in the prior case where, with respect to summary judgment, you lay bare your proof.
Well, I mean, the thing was, the judge did indicate that there were certainly questions on the damages, but that would have to be proven at trial. She didn't necessarily find that there's absolutely no damages, but they're going to have to prove them at trial.
Well, there were absolutely no damages here that were ever shown. Back in 2015, when this case started before Justice Owing for preliminary injunction, there were no damages that were shown. Through thousands of documents that we produced, there were no damages that were shown. We're dealing with the leader of the industry, self-proclaimed leader of this electronic industry, and he testified, I don't know of any damages. The court itself said the damages theory that the plaintiff presented was, quote, woefully inadequate.
Well, but of course, since a lot of this case has to do with the adverse inference that the court granted, part of the reason they may not have been able to prove the damages as definitively as they would have liked to was they didn't have the evidence they would have had if there hadn't been a destruction of the WhatsApp conversations that went back and forth. So it's kind of both connected. And I think the judge indicated that if there is going to be an adverse inference, then they'll be able to at least put forth damages. Will they win or not? I can't tell you.
But let me address that directly, Your Honor, because the judge said that there were three principal reasons why she issued an adverse inference in this case. One of them was that the defendants were tardy in addressing the problem. That, we don't even know where in the record the judge received or obtained that information. The case started with a preliminary injunction. After a few days, this upstart defendant who enters into the industry from being a teacher in a school comes in, starts a business with an assistant, knows nothing, quickly grabs on to what it is. It is a nanosecond type of industry. Thousands of people, members of the industry compete for every single transaction. All information is exchanged. He said it, the adversary said it, and our unrebutted expert in the industry said it.
That's not what the adversary is saying. Isn't the adversary arguing that there is confidential information about how they do their pricing, and that is what was disclosed in those destroyed WhatsApp conversations? So it's not just the identity of the customers, but it's at what price they were selling the goods.
But that is the mistake that was made, because in this industry, all pricing lists, and we've put it in into the affidavits and even
But obviously, everyone's not selling it at the same exact price.
This material is available. This is how you get, if you click on, you get that transaction immediately. And it has to work with a nanosecond. Everyone knows what's available.
Well, that's right. That's your position. But obviously, the other side is taking a different position and has articulated a different position and is certainly arguing that they have confidential information, which was disclosed by their sales representative in violation of the confidentiality agreement. You're disagreeing, but I don't know why that doesn't just raise an issue of fact versus that your version is correct.
We're not only disagreeing with that, we're disagreeing because the source of the information and everything that possibly, and we argue about it and we disagree, but could have been transferred or given over to our client, they had. That phone with the WhatsApp messages, they had from their own employee's phone. All of those messages. They've never said they didn't. In fact, in the record, their own attorney admitted it.
They're not saying they didn't have all the messages. They're saying they had some of the messages for some period of time, but not all of the messages, and that your client deleted the ones that they didn't have.
They're not saying that they don't have all the messages that were done. They're saying that my client's phone did not have all the messages. They had all the messages from Mr. Strauss's phone. It's the same communications. No one claimed that Mr. Strauss didn't have, they took away his phone. They confiscated it immediately before anything happened, before my client knew what was going on. They confiscated his phone. They had all the messages. They went for a preliminary injunction. Then we started with discovery. Immediately, it was found out with this WhatsApp situation. And let's talk about what happened with the WhatsApp situation. No one at that time could have ever realized that the WhatsApp was something that was not like email that could be transferred over automatically to the next phone. You trade a phone, you get a new phone, all your
Isn't that the whole
information and
benefit of
data is
WhatsApp,
gone.
that the messages don't get retained by WhatsApp? That's why people use WhatsApp.
Excuse me?
That's why people use WhatsApp. That's
Now
that's the whole
everyone knows
basis
that.
of the app.
And no one knew that at the time. They never disputed that. No one. That's why Justice Owing did not take any measures against what happened. It was understandable. But more so, when they have thousands of documents, they had every single sale my client made. They have that. And can they match that as to what they could possibly have sold that? They didn't have one. Not one page, not one document in 7 years. They have nothing. And their CEO said they have nothing. Not because they couldn't get the information from my client's phone. They had the information from their own employee's phone. They had everything they needed, and it's all in the record.
Okay, let's hear from your adversary, and you'll have a few moments to respond. Thank you.
Good afternoon, Your Honors. Jonathan Cooper for the plaintiff respondent. I want to start with noting that it's hard to imagine any instance where spoliation sanctions would be.
Counsel, address what your adversary said, that through Strauss's phone you had all the same messages, that there were no gaps.
That is absolutely untrue. Page 376 of the record, paragraph 34 of the complaint, Judge Singh, it is very clear that when they retrieved Mr. Strauss's phone immediately prior to commencing litigation, this was all they were able to retrieve, and we produced that in full in the record. There's about 100 pages in the record, which is the sum total, which is a series of chats between October and November 2014. Those are the only chats that were recovered from Mr. Strauss's phone. And in terms of the additional gaps, that's also noted at pages 886 to 889 of the record, which comes from their phone, and it shows on its face significant gaps that were outlined in the letters from May of 2015 to, I believe it was Justice Owing at that time. Simply put, there is no substitute at all for those 8 months worth of missing WhatsApp chats. As we detailed in our brief, we highlighted several of those chats which detail how Mr. Strauss was giving the SGM defendants live pricing information, actively competing against his own employer by feeding these leads to the SGM
So what about
defendants.
Mr. Zalmanovitz said that, oh, the pricing information is something you should just click on and find? Is that?
Absolutely untrue, and there's no basis for that in the record, Your Honor. And he was unfairly using his inside information as to RCS's pricing, and this is, again, detailed in our briefs, to say, hey, you can actually undercut my own employer to make these deals. And there's just no universe, as I indicated in the record in the oral argument before Justice Maisley, there's no universe where that's okay, where you're working for your employer, actively working to undercut them at the same time in exchange for a payment that you're getting from this competitor.
So let me ask one other question. Mr. Zalmanovitz started by talking about the problem with damages, which Judge Maisley recognized had been a problem, and I explained why it seemed there might be some justification with the adverse inference. But even with that, is your client going to be able to show that, in fact, that your client was dealing with the same clients, that the plaintiff was dealing with the same clients, so that they actually undermined them or took away some of your business, so that you really did suffer any damages? Are you going to be able to show that?
With difficulty, I believe we can. And that's actually outlined in Mr. Fite's affidavit, which is in the record. because his damages computation are saying, these are the deals that we did with these same exact customers at that same time with the identical products, and this was our typical profit margin
So we
on those
probably
products.
would have been the one they were dealing with if if Mr. Strauss had not given the information to our competitor.
Correct.
How about the unjust enrichment claim? What are the damages there?
The unjust enrichment, again, that goes to the spoliation issue, and it would be theoretically duplicative of the same thing from the unfair
Just
competition.
answer my question. What are the damages? What damages are you claiming with respect to unjust enrichment?
It was simply another cause of action trying to get to the same relief of damages, Your Honor.
So you're seeking lost profits in the unjust enrichment claim?
It's the same type of lost profits that we're seeking. It's the
Are you
same.
can you get lost profits for unjust enrichment?
I believe so,
Is
Your
there a
Honor.
case law that supports
I
that?
believe that was part of the E.J. Brooks case, and also this case, this court's opinion, I think in the U.S., something to be Shearer, if I remember that correctly.
Okay.
If the panel has no further questions for me, I will rest. Thank you, Your Honors.
Thank you.
Thank you. I'll be very brief. We have the industry expert, Mr. Lieberman, who put in an affidavit that is unrebutted that all of this information was exchanged by thousands.
So in other words, in this industry, everyone knows what the rates are.
Exactly. And the reason why my client was successful later on is because his terms that he offered were better, not pricing. His terms were you could pay in 30 days.
So what's your
never did that.
explanation for why there were all these exchanges going back and forth between their employee and your principal of your company?
Well, we've
And payments
established,
going back and forth?
those
Just by
exchanges.
chance?
Because, no, there's exchanges with everyone. Everyone who's on this exchange, on these exchanges, exchange information. They admitted that they even exchange information with my client. They go to an exchange and they talk about this one or that one. How's that credit risk? How's this one? How have you done business with that one? All of that is the same. The question is, do you have inventory available? Do you have terms that would be more satisfactory to them? That's the kind of industry, and that's what Justice Oing recognized right away, and we wrote a quote from his opinion in our brief. Your Honor, if I just may add one more thing, which is that recently this court and Justices Kern and Moulton were on the panel. It was Domingo v. 541 Operating Corp., 210 AD 3rd 423. And it says some things very interesting with respect to the spoliation. Number one, that you have to show that the sole means of establishing your claims is what was taken away from you. That is not true here at all, where thousands of documents, bills, invoices, all of those records were provided to them. They have their own records, which they didn't produce. All you have to do is match them up. But there is not one single sale that they lost. Secondly, the court said that even in that case where there was no explanation provided why documents weren't preserved, which is contrary to what we did, we explained the situation that we had. Nevertheless, the court said that it falls short of establishing what is necessary, which is, quote, culpable state of mind on the record. You cannot say that there was any culpable state of mind on the record for our client to have given his assistant his phone and then inadvertently things
But that
were overwritten.
coincides with Mr. Greenwald admitting that he extended loans to Mr. Strauss, loans, quote unquote, to Mr. Strauss, right?
That's correct.
So those two things together, create an issue of fact, it seems to me.
They created an issue of fact as to spoliation, which is why the court should not have ruled that there was gross negligence here.
Okay, well, thank you both very much. We'll
Thank
certainly
you.
take another look at these papers. The next case for oral argument is RCM CMG Portfolio versus Giordano.